Okay. We're ready.
All right, at this time, I'd like to call the Ventura County Campaign Finance Ethics Commission to order. Madam Clerk, would you please read the roll call?
Commissioner Johnston. Here. Commissioner McBride.
Here.
And Chair C.
Here. Okay, agenda review. May staff please provide agenda updates for the commission?
Yes, good morning, Commissioners. Good morning. The Commission Investigating Council is requesting regular agenda items 6 and 7 to be heard together. Regular agenda item number 8, staff is requesting that agenda to be pulled. Case number P201202 will be agendized at a future meeting date. Regular agenda item number 10, addition of Exhibit 10C, letter submitted by Mr. Bob Roper was made available to your commissioners. Regular agenda item number 11, addition of 2 exhibits, 11D, letter submitted by Mr. Steve Bennett, and 11E, letter submitted from Mr. Craig Steele. Thank you.
All right. Does the commission have any questions of staff concerning the amended agenda matters?
Yeah, I was curious as to why 8's being pulled. Is that a request from someone?
Yes, from staff. Somebody want to address that issue about why 8 is requested to be pulled?
Yes. Upon review, it appeared that there was an error was made, a miscommunication to the investigating counsel, and that actually the matters that were being addressed were not part of that case number, and actually are addressed in agenda item 9. And so that matter will be pulled and brought back with at a future time on that case, on the allegations that were actually brought in the complaint related to that case number.
So it will not be continued, it will be re-agendized under a new heading for the next meeting.
Correct. It will be the same case number, but yeah, there will be a different materials will be presented at a future meeting.
All right. Next item is the review
Mr. Chair.
and,
Mr. Chair, can I ask for a motion to amend the agenda as stated, please?
So moved.
Second.
Thank you.
thank you. Next item is review and approval of meeting summaries for November 2nd and November 16th, 2012. As a comment, I have reviewed those summaries, and I like them even better than the summary minutes that have been previously prepared, because they were in greater detail and provide more assistance to me in recalling what happened. I also understand that staff spent extensive time reviewing the tapes, which is really no fun, in order to come up with those reviews, and I appreciate that extra effort. So any questions or comments about the meeting summaries for those 2 prior meetings? Is there a motion with respect to them?
This is a comment. It's not for correction, but Mr. Becker, Don Becker, the citizen that testified, my recollection of his comment on the issue of the violation versus an apparent violation versus a formal complaint, he was merely expressing to the average. I thought he said that it was just to an average citizen it appeared that one had more merit than the other, as opposed to one actually having more merit. But
Yeah.
it doesn't require correction.
And I believe the clerk's position was that the 2 had equal dignity as far as the clerk was concerned. You need to turn your mic on, too. All right, do I have a motion with respect to the meeting summaries?
Yes, so moved.
Second.
All right, any opposition? And the summaries are approved, and our thanks to staff for their preparation.
very much so.
Any commission member or staff comments at this point in time? I should point out that our regular Assistant County Counsel, Robert Ori, our regular counsel, Assistant County Counsel, Robert Oriana, will not advise the commission on any matter that arose from the Bennett versus Roper election issues, which on the agenda today, I believe, is numbers 9, 10, and 11. In his place, Mr. Matthew Smith will be advising the commission, and Mr. Oriana will be advising his client, the clerk of the board, Mr. Lunt. Any questions? Any other comments from commissioners? All right, then moving on to number 6 and 7, which we'll handle collectively as requested by council. We'll hear from Mr. Steele regarding his proposed recommendation.
Good morning, Mr. Chairman, members of the commission. Pleased to be before you this first meeting of the new year. We are, as you approved, taking items 6 and 7 together because I am recommending a global resolution of the two cases that are noted in those agenda items. It's case number P10-001 and RP10-003. These are the last two complaints left over from the 2010 election cycle. They have been the subject already of some substantial discussion before the commission about a year ago. The two complaints, briefly summarized, are that in the first, the respondent committee accepted transfers from another state candidates committee, her own candidates committee, but another committee, in the amount of $8,500. Those transfers were properly reported on the both committees' forms. They were timely reported. They weren't concealed in any way. They were made apparently with the respondent committee's belief that the ordinance did not prohibit those transfers and could not prohibit those transfers based on an Attorney General's opinion and a reported court decision. The report was later amended to show that that chunk of money, if you will, was in fact contributed to the original committee by individual contributors. It didn't change the amount or change the fact that an original transfer had been made, but it was an attempt to show that the money had been raised in compliance essentially with the county's ordinance, even though the contributions had been made to a state political action committee. The respondent's attorney, when the complaint was filed a lengthy legal brief, if you will, or a response to the complaint, and aggressively addressed the issues that had been raised, and raised, in my mind, some serious threats of litigation against the county if that enforcement action were to proceed. And the response of the respondent, the written response that was filed by counsel for the respondent, is a part of the record and has been presented to the commission. The second case arising out of the same set of elections, case number RP10-003, involved two contributions of $700 each, one from a corporate entity and one from an individual who was listed as the, quote, owner of the corporate entity. As you know, the ordinance does not permit essentially double dipping from the same general source when an individual has control over a corporate entity or a business entity or a nonprofit entity, that individual can't make a contribution from the entity's account that he or she controls and also individually, because that would be a way to avoid the contribution limits. Again, in this case, both contributions were reported. There wasn't any effort to conceal the contributions, and in fact, the violation was apparent from the face of the reports that the committee filed, and the committee did not really vigorously contest the allegations or the complaint or the fact that the complaint was made in violation. After some significant consideration of the legal arguments had been made and the way the case was proceeding, about a year ago, I was before the commission to discuss what ought to be done about this case. Ultimately, the commission, with I think the helpful suggestion of counsel, indicated that one global resolution of the case would be advisable. I feel that further prosecution of the larger issue in this case, the transfer complaint, would lead to pretty protracted and pretty expensive litigation, and I don't feel that it's certainly my role to lead the county down that path when I can resolve these cases in a way that is consistent with what we've done on other cases. So in this particular stipulation, I'm recommending that the global resolution of these cases be approved by the commission, and that the respondent be ordered to pay a fine of $700, which is the amount that was illegally contributed in the second case, the full amount, and actually one of the larger dollar amount fines that I have collected over the course of my time with the commission, especially in a first offense kind of a case. We have the signed stipulation that is before you. The respondent has signed it and provided a cashier's check, which has been provided to the county. So we're prepared to recommend that the commission approve this stipulation as final resolution of the case.
Thank you. Are there any questions from the commission to Mr. Steele on this matter?
I don't want to prolong this at all, but on the issue of the Attorney General's opinion and the intra-candidate transfer, is that being addressed for future purposes, or are we just setting that aside for now?
I don't know what county council is doing on that issue. My intent, if the case is resolved and that issue is put aside, my intent is to write confidentially to county council just about some issues that arose in the case,
Okay.
and let county council obviously advise their client from there.
Okay.
I want
Thank
to
you.
make them aware of some issues that came up.
Mr. Johnson?
I move to accept the recommendation from council.
I had one comment before we proceed with, well, is there a second?
Second. That's on 6 and 7.
Correct. I just had one observation, and that was that it is frustrating to me not to get a resolution of the legal issue because it gives no guidance to future campaigns about whether or not much more substantial amounts of money can be transferred from a state campaign fund to a local campaign, and I would like to see a resolution of that. With respect to the fine, I agree with Mr. Steele that the fine is reasonable under the circumstances. I have a certain sense of frustration that it costs the county of Ventura tens of thousands of dollars to support the activities of this commission, and yet the amount of fines don't seem to support the investment in some ways. Having said that, the ordinance provides for fines of 1 to 3 times the amount of the donation misadventure, and this is 1 times it, and it is consistent with what we've done in the past. So I join and agree that it's an appropriate thing to do. All in favor?
Aye.
And we authorize the chair to sign the settlement agreement, I take it?
Yes.
All right. No objection, the matter is approved. Okay, item 8 has been pulled. Item number 9. Mr. Norman.
Morning.
How are you today?
I'm fine, thank you. I think this is matters in joining with the next agenda item. I think they were both addressed in my report to the commission jointly. Violation numbers P 2012-03 and 04. Mr. Roper has agreed and will not appear today in response to agenda item number 10. And number 9, I don't think Mr. Bennett has any objection either to this. This is a situation where both candidates were in the primary campaign and then became candidates in the general election. And they filed the required reports and intended to have the reports cover both, but they were late in filing the second report. And my recommendation was that the complaints be dismissed.
Any questions?
No, I think it's pretty apparent.
Both
I would
candidates
so move.
engaged in the same behavior, and both candidates did what was indicated to them to be an appropriate solution, and I agree with the recommended action. Is there a motion with respect to 9 and 10
So
collectively?
moved.
Second.
All right, any objection? Hearing none, 9 and 10 are approved, and a declaration that no violation has occurred will be posted in each event.
Thank you.
Thank you. All right. Item 11. I think that as a preliminary matter to item 11, there are 5 separate complaints to 11, and they all deal with the supervisorial race between Supervisor Bennett and Mr. Roper. The matter is not set today for a hearing on the merits of any of those 5 matters. There have been recommendations from our investigating counsel with respect to each of the 5 matters, and in the event that the commission follows any of those recommendations, the matter will be disposed of in that fashion. In the event that the commission does not accept any of the 5 violations, then the matter will be forthwith set for an evidentiary hearing. The participation of the parties today, and I've had the question arise, is it possible to speak to the issue of the propriety of the proposed dispositions? May the candidates respond, may the clerk respond, and my feeling is clear that the ordinance provides for such responses. I do not believe that those responses are limited to 3-minute public comment, but that they should be free to address why or why not they feel that the proposed disposition is appropriate or inappropriate. So, hearing that, there's some threshold issues. We have 2 sets of recommended actions. Mr. Norman has recommended that 2 of the matters be disposed of in a particular way, and Mr. Steele has recommendations on the remaining. So why don't we take up first the issue of Mr. Norman's recommendations. Mr. Norman?
Thank you. I will address numbers 2 and 4 of the 5 separate violations in this complaint. And I will start with violation number 2, and this has to do with the report, and the complaint alleged that the report indicated that there were
Excuse me, Mr. Norman.
contributions.
Could you speak into the microphone? We're having a little trouble hearing you.
Sure.
Thank you.
All right. I'm back to numbers 2 and 4 of the alleged 5 violations in this particular matter. And number 2 alleged that there was a violation because the report that was submitted to the clerk showed contributions in excess of the limited amount. And the ordinance in question deals with expenditures, not contributions. Mr. Bennett has now raised the point, he says, well, the same form in another section has an amounts listed, I think it's 9,000 something, for expenditures. But that wasn't his complaint. His complaint was based upon contributions, and the ordinance did not require the clerk to do anything further in regard to those contributions. I don't know if Mr. Bennett intends to file another complaint or to somehow try to amend his complaint to bring into play the expenditures. But that wasn't part of his complaint, and that's why I dismissed the action. I recommended dismissal of the complaint. The other violation is number 4, and if I read Mr. Bennett's response that was recently submitted, he intends to file another complaint to flesh out what he considers to be inadequacies in the reports that were filed. Based upon what he submitted earlier, I found that there was no violation. I found that the clerk did not have a duty to determine the accuracy of the numbers reported on a form, nor that a particular attachment was readable in form. And I didn't see any evidence that the attachment was not readable. Mr. Bennett indicates that he will now submit another complaint to, again, flush out what he feels are the inadequacies which required action by the clerk under Section 1298B. So I think we'll wait for Mr. Bennett to file his next complaint if he chooses to do so.
Thank you. I guess procedurally we should hear from Mr. Bennett concerning those two, but there is an underlying issue here about whether or not, well, let's hear Mr. Bennett on 2 and 4, please.
Thank you very much for this opportunity to address you, the 3 commissioners. This is a little bit unusual in terms of, depending on where the commission stands with the other recommendations, Mr. Steele, it certainly influences my thoughts and thinking about the recommendations to dismiss in terms of 2 and 4 and my refiling. But right now, I simply will, and I appreciate the fact that I was uncertain as to whether to comment on this and use my precious 3 minutes up on this, but I appreciate that I'm not limited to that. I think that we'll have better government as a result of that. So I will point out that I'll be making these other comments, but with regards to these 2 complaints, the narrative that I put in my complaint, as I mentioned to you, referenced the $22,000 in contributions. I intended, quite frankly, I was dealing with 5 complaints and trying to timely get it in before your last committee meeting. I intended to also add the expenditures, and I remember specifically going to look up the expenditures and then failing to get back to the narrative. So I recognize that the narrative is not there. The question is, I think a fundamental question is if the investigating attorney or the initial review attorney has evidence, or if the commission, now knowing that there was evidence presented, which is the report that shows that there were $9,000 in expenditures out there, if I should be amending the complaint, your operating procedures allow you to amend a complaint. I'm not sure what that means, whether that means allow you to have me amend the complaint. I can amend the complaint, or I can simply refile the same complaint, but reference the words expenditures. The piece of evidence that was critical was presented, which is the 465 report. I would offer to you that that was the second report that the clerk had received of independent expenditures by this committee. The first report on September 26 very clearly identified that these expenditures were for the race between myself and Mr. Roper, because it identified the purchase of signs for Mr. Roper's campaign. So I think it's very clear that that's what it was. And that gets to the question about the first complaint, which is, does the clerk have a duty to inform if they receive reports that are of an independent expenditure but are not on the clerk's special 1275 report that is out there? I would contend in the comments that I submitted to you that defies the normal construction rules, which say that the first rule that should be applied is interpret it with its plain language. 1275D does say that the clerk has the duty if they receive a report. This was not just any old report. This was a State of California report. The clerk is very accustomed to receiving State of California reports, as most of the reports are. This was a State of California report. It was titled Supplemental Independent Expenditure. I think it's very clear, and the expenditure was identified with a copy of the signs being purchased for Mr. Roper. It just comes down to this question of number one, is the clerk absolved of his responsibility to inform under 1275D because county council advised him that he does not have a duty to inform unless he receives a 1275 form. If that's at a minimum, I would hope that the commission would advise county council that that is not the proper interpretation of the ordinance. I can't imagine the language being plainer or more clear in the ordinance. The other thing that I would point out about that, which I reference also, is that interestingly, and I think importantly, the clerk did finally on October 17th, after I pointed out that there were these independent expenditures being made, sent me a letter, which I'm prepared to submit to you today, sent me a letter, and it identified that independent expenditures were being made. And the evidence that they used was the very 460 report that I referenced that was filed on September 26th. Now, on the one hand, the clerk used that, and the actual language of the letter, which, if you'll excuse me, I have it in my briefcase right here. I'll grab that. I didn't expect you to move through your agenda to item 11 quite so quickly. I will have to. I believe I've left that. But the actual letter says, pursuant to 1275D, you are informed that an independent expenditure has taken place. Now, I believe that I should have received that notification within 24 hours of the September 26th filing, certainly within 24 hours of the October 5th filing, and it shouldn't have required me to go and point that out to the clerk. And I don't believe that the clerk, I think that the inconsistency in the logic, the clerk can't have it both ways and use that as the evidence of the independent expenditure to send me that official notification and now say that that does not provide that sufficient evidence. So whether I refile that or not will obviously partially be a function of your thinking and decisions on item A, or complaint number 1, which is separate from complaint number 2. But I can simply list that as expenditures or amend that report. Same thing with item 4. I would offer to you there really are 2 fundamental questions in front of us here, and that is the provisions in the ordinance that says the clerk has a duty to notify within 24 hours if they are aware of, if they receive a report of supplemental independent expenditures. And the other one is that the clerk has a duty to promptly notify if people fail to file. And associated with that is the clerk has a duty to review the forms to see if on their face they comply with the filing requirements. I would offer to you that the 1275s in item, that I'm referencing in item 4, that the 1275s that were filed, the first ones that were filed, were so incomplete that it was impossible for me as the candidate or the clerk to use them to begin to make a determination as to whether the threshold limit was being exceeded. And that is an important part of our ordinance. We are trying to encourage candidates to accept the voluntary expenditure limits because we're trying to decrease the influence of money in politics. By decreasing the total amount of spending, we can do that. It is harder to get candidates to accept the voluntary expenditure limits if they believe that independent expenditures committees can come and just spend enormous amounts of money attacking them while they are limited in their spending. As a remedy to that, we have in the ordinance, and many ordinances have this, a provision, an escape clause that says you are not held to the threshold if independent expenditure committees come and disadvantage you or advantage your opponent with their expenditures. So it is extremely important to be able to make those determinations, and it's extremely important to be able to do that in a timely manner. So I believe you couldn't write it clearer than what the ordinance does, and in fact, where it says that they are supposed to review on their face. Some of those 1275 forms had, where the amount was supposed to be listed, had the date listed. Those were submitted to Mr. Norman as part of my complaints against the Citizens for a Better Ventura County for filing wrong. They were not submitted to Mr. Norman as part of this, so I can see why the record would not be complete, and I did not clearly point those out at that particular point in time. But it does emphasize, I think, the timeliness of that. So I wanted to get those things on record. The final thing I would like to get on record here, as while we're talking about these 2 items, is the clerk points out and cites in one of the attachments submitted to you the FPPC guidelines saying that the clerk does not have to determine the accuracy of the figures. I completely concur with that. I believe that deflects you and the public from recognizing what is the real issue. On that same guidelines from the Fair Political Practice Commission, the paragraph above it and the top paragraph, and you can look at that, and I believe it's items 11 in your attachment, but I can get that. The very first one says the exact same thing our ordinance says, which is the clerk has a duty to review the forms to be sure that they, on their face, comply with the requirements. Now, that is in the same FPPC report that's provided to you by the clerk saying you don't have to determine accuracy. I agree, the clerk does not have to determine accuracy. The question is, does the clerk need to review that form? I was looking at this form and saying, how can this form help us at all, help me understand what this independent expenditure, and yet the independent expenditure committee can say, we filed the form, and then we are delayed that much longer. And days make a difference when you're late in a campaign and you're close to that election filing. So I would offer to you there should be a high standard for compliance with that basic function that is part of the FPPC requirement and part of our ordinance, that the clerk has a duty to review the forms to make sure that on their face they comply. And final thing that I would mention with that is that the That timeliness, or that the critical importance of doing that is fundamental to much of the disclosure requirements. And the issue of promptly has been raised, that there is no definition of the issue of promptly. And yet I can imagine that if we create a definition of the issue of promptly, that will be challenged, that could potentially be challenged. But certainly common sense needs to be applied to promptly, and notifying a committee the day after the election when it has much less meaning, and it certainly makes the word prompt less meaningful. When you receive a report October 25th that could have a material effect on the election in November. So thank you very much for the opportunity to clarify those, because I can keep those out of my comments that I will make as we talk about Mr. Steele's recommendations and findings. Thank you.
I did want to give you the opportunity to respond to those two first, but I think that perhaps this is an appropriate time to take up the underlying issue to which I alluded. You can go ahead and sit back down. I'm going to take up some other issues. One issue presented both in 2 and 4 and in the other 3 complaints under item 11 is the proper interpretation of the statute. We can hear argument. I assure you, I have read all of the agenda material as prepared, and Mr. Steele's letter of last night, and Mr. Bennett's letter of last night. I'm completely familiar with everything you just told us. But the issue before the Commission today is not whether or not those sections were violated, but whether or not dismissal is the appropriate remedy. Hence your opportunity to say why you thought they shouldn't be. But underlying that is, well, if we set up for an administrative hearing, or a full hearing, an evidentiary hearing, what is the scope under the ordinance of the action that this commission could take if those allegations were found to be true? Now, unlike candidates' misadventures, the penalties for other duties specified in the ordinance, in my opinion, are not specified. So, since all 5 of Mr. Bennett's complaints relate to duties, some of which are unquestionable under the ordinance, placed upon the clerk, the issue is, and he has raised it, does this commission have the authority to order or to find the clerk personally responsible for these alleged misdeeds? And if so, what is the scope of the action that can be taken in response thereto? I don't know the answers to those, but it doesn't seem to me that there's a lot of utility in setting each of these 5 matters, because it's apparent that unless the commission decides to dismiss the 2 requested matters, there will be no resolution of any of the 5 matters, and all of them will have to be set. Before we set them, I solicit from my fellow commissioners what their thoughts are with respect to the other 2 issues, aside from proper interpretation of the statutes, whether it is a report or a report bearing a particular number and so forth. What is the meaning of the clerk's duty? And 2, what's the remedy for a violation of it?
Well,
Mr. Chair, I would just like to point out that I intended to address those things because I received Mr. Steele's letter well after I submitted my comments to you yesterday afternoon. And I thought you were inviting me to talk simply about Mr. Norman's. I would like to be able to address the questions that are raised by Mr. Norman's letter. I'd like the opportunity to enter public testimony about those before you make a decision on that fundamental question. So I do have comments ready for that. That's what I've spent my time on.
Well, one of my thoughts is we may need some legal assistance. The commission may need some legal assistance in determining that underlying issue. I don't know. Commissioners?
Go ahead.
Not quite sure how to organize my thoughts, but and not being steeped in the law as you gentlemen are, apparently a number of people in the audience, but it seems to me that the underlying concern here is the Board of Supervisors has enacted an ordinance that requires the performance of an independently elected official, the clerk, to carry that out, and then there's a dispute over whether or not that has been carried out and whether it's intentional or whether it's a misunderstanding. One remedy, if it's a misunderstanding as to what it means, is for us to just simply express what we believe it means, but that does not require, I don't think, an independently elected official to do anything differently than to exercise their best judgment as things come up. So I'm kind of wondering what authority we would have over that particular aspect of this. And even if we had authority, what would be the most efficient and effective way to carry that out so that we don't end up with, volumes of stuff that a lot of which I got in the mail during campaigns, and I'm not sure that that really gets us anyplace. My experience is sometimes there's a difference between what someone would call common sense logic and what the law requires. And it seems to me we're kind of in that area that obviously common sense would say that the day after something's over is not timely, but that doesn't necessarily mean it wasn't done promptly, depending on when that person who had to take the action had the opportunity to take the action. Things happen rather rapidly, particularly and sometimes deliberately towards the end of campaigns where information is not necessarily forthcoming. I think that's a flaw in kind of the whole process that we're trying to administer, is trying to control something that there's always kind of a gray area. So I guess without going to the merits of each individual complaint, it just does seem to me questionable whether or not this commission would have any really effective authority over an independently elected official. I may be way off base, but it would seem like if the Board of Supervisors enacted the ordinance and felt that it was not being carried out by another party, that maybe it would be between them and that other party and the courts maybe to, if you're trying to do it legally. If you're trying to do it cooperatively, it's simply, a clarification and an explanation, but I don't know that that would require that official, the clerk, to do anything differently. So I don't know what value those comments have, but that's what's in my head.
Mr. Bragg?
I think we have several options today. One is that we could set all of these 5 allegations for a hearing. And the other is that we could, if I understand it right, dismiss all of them.
Save and except perhaps number 5. I don't know if there's a recommendation to dismiss it.
Well, that doesn't mean that we can't make a finding.
Oh, I'm sorry.
That was a choice.
Yeah.
It's a choice.
Sorry.
I mean, we could do it. But the real issue is, and I agree with the other 2 commissioners, the real issue is, does this ordinance really authorize this commission to find the county clerk, an independently elected official, personally liable for failure to perform a duty set by a county ordinance, and not only liable, but liable for a dollar amount, which could be $5,000, $10,000, $25,000. That's the issue, and I don't know of a situation where there has been a county ordinance adopted which makes an elected official personally liable for the manner in which he carries or fails to carry out his duties. It just doesn't strike me as being the typical case. If an elected official isn't performing the duties, is to determine by mandate or have him mandated to do the duty, or go in for a declaratory relief action to determine what the duties are, if there's a true dispute over those duties. I read this ordinance, and to be honest, as I read this, I'm not sure the ordinance was written with the intent that those violation provisions apply to other than the candidates or the committees, what have you. I have grave doubts that this ordinance was written to make those penalty provisions in 1296 and our authority and 1294 applicable to the clerk in this situation. It just goes beyond what we normally have seen and what we normally see in governance, especially at the county level.
Will I be allowed to address this issue?
Just a moment, please.
I don't know if this is a good analogy or not, but it seems, I mean, you're reading all of this and trying to read between the lines, maybe in some cases not so much between the lines, is that in the courts there is a concern of something called jury nullification, where someone can basically stand in the way of the law, working the way the law is written just by the use of their judgment. And it seems like that's a concern that we have, this ordinance as it was created puts someone in a position possibly to nullify what some people might believe to be the purpose of the ordinance, or maybe even common sense might say. But I don't know how this commission can really address that.
I agree with those comments that the commissioners have made with respect to questioning the ultimate authority of the commission to take action. I have less doubt that the Board of Supervisors, in adopting the ordinance, had the expectation that when they presented the duties of the clerk, that they would be in some fashion enforceable, or that the board, in adopting the ordinance, requiring notification of parties of the expenditures above a particular amount within 24 hours, had any expectation other than it would be performed. This is the plain meaning of the ordinance. But the question is whether or not the board had the authority to make that determination impliedly in adopting the provisions of 1275 and the other allegedly violated. Mr. Bennett, I think you ought to be given the opportunity to respond, but it's going to be difficult to reach a meaningful determination today without some direction about where we're going to go with that underlying question.
Thank you very much. I appreciate that opportunity to respond, and I appreciate the challenge that's raised here. I received Mr. Steele's comments at after 5 o'clock last evening. It raises substantial issues and questions that I certainly had not been focused on. I'd been focused on the merits of each of the complaints that was out there. Pardon me, but I'm going to try to present to you my thinking as I was trying to put that together both last night and this morning. So I'm going to read some of this to try to make sure I get this said properly. You received the findings of Mr. Steele late yesterday afternoon. I received the email also after 5 o'clock. I hope you'll consider how short of time you the public and I have had with Mr. Steele's report as you evaluate both the quality of the testimony I'm giving this morning, which I will admit is inadequate to address all of the questions that you're raising here today, and also the speed with which you decide to take action and accept the recommendations either to dismiss or to accept the clerk's contention that he is not to be subject to administrative hearings. So I recognize these are big questions, and I don't think that hearing a recommendation yesterday late afternoon and making a decision at 10 o'clock this morning will be in the best interest of the public. And I would offer these as the reasons why. You're being asked to establish some important precedents today if you accept the contention of the clerk that he should not be held responsible. At a minimum, we should research that. What are the legal questions? Mr. Steele has not given you a recommendation that you should not do that. He says, what is your, with complaint number 5, what is your opinion of the clerk's contention? I assume you just received that information yesterday afternoon, and certainly the public hasn't had time to respond as to whether the clerk should be there. I certainly haven't had time to do the legal research with regard to that. But I would offer this. It is a question, if you accept that and today say the clerk is not, if you accept the clerk's arguments today, you will dramatically be decreasing the accountability that needs to be a part of the ordinance that is out there. For our campaign ordinance to work properly, these things need to take place. The clerk needs to inform candidates, particularly those who have accepted the voluntary expenditure limits, when those independent expenditures are made. For the ordinance to work properly, the clerk needs to determine if all the total expenditures have exceeded the threshold that releases a candidate from the voluntary expending limits. The clerk needs to review the forms when they're filed to determine if on their face they provide the proper information, and the clerk needs to promptly notify. Those are duties in there. That needs to happen, and there needs to be a sense of accountability if the clerk, for whatever reason, is not doing that. I appreciate the comments of Mr. McBride, and we're not trying to hold the clerk to some monetary penalty. And that is something that can be clarified. As I mentioned to you last time here, this is a work in progress, constantly trying to improve the ordinance. And the commission, the investigating attorney could very simply say, we're not looking for financial penalties here from the clerk, but we are looking for something that holds the clerk accountable to move forward. We have the potential, with reading Mr. Steele's findings, that nobody, when I interacted with the clerk's office personnel, almost consistently they said, I don't know, I'll have to ask. And then unknown people are asked, and they come back to me and say, no, we can't do that. I can imagine one of the things that Mr. Steele points out is, well, who do you hold negligent here? Because, trying to prove that somebody intentionally, didn't do this is one thing. Negligence would be another thing. Who do you hold? I could imagine if I filed against that front counter person, their response would be, I just did what my bosses told me to do. And we would be constantly doing that. A fundamental question ought to be, is the clerk responsible for the proper training, the proper oversight of people who are supposed to carry out these duties? Nobody wants to create a situation where somebody, by an oversight, blows something. But if by an oversight they miss something and it's pointed out to them and they still refuse to take timely action, that's a different matter, and I offer that's what's happened in this situation, and it's not clear. So accountability is really important. The other thing that I think sets a dangerous precedent is that the clerk has contended, and Mr. Steele appears to have accepted it, that if a report is postmarked October 25th And I would offer to you, there's no clear evidence. The FedEx document that's in there, I cannot find a date on that document anywhere that was returned. But that if a committee files a document overnight and ostensibly postmarks it and gets it returned to them, that they can hold that report until after the election. And the clerk has no responsibility until after the election to notify them that that report hasn't come in. That report is an essential part of that. Now, that's in Mr. Steele's comments as to why this is it's difficult to, why potentially we should be dismissing complaint number 3. And that would not be a healthy precedent to move forward. But I've identified those responsibilities, and that's the duty to review on their face the forms and the duty to inform in my earlier comments. There needs to be a sense of accountability. If you accept the arguments of the clerk today, I think we will dramatically decrease that sense of accountability, because I can imagine walking into the clerk's office and the front office personnel politely saying, well, I have to check, and coming back and saying, we're not going to do that. And if you have to, if there are some other administrative remedies for a citizen in that situation, I would offer to you that they will be much delayed. They will not result in the kind of response that we would get, I believe, if the clerk feels that they are responsible. So at a minimum, I would hope that today you would decide to continue this and research this further to determine what the best thing is to do. But to accept this at this point in time would set a precedent that would decrease accountability. It would allow all of us to get our thoughts better together in terms of this, and not dismiss any of the complaints until you address this particular issue, is what I think would be the best thing to happen. And I'm sorry for being a little bit rambly here, but it's been difficult for me to adjust to from being ready for one kind of hearing to the issues raised by Mr. Steele's letter. And everybody is trying to work this out and try to have this work. I would offer to you, you have this final point, and that is the ability for Ventura County to have a good, strong ordinance that improves and makes our county one where elections have more integrity than maybe other places, is very much wrapped up in this issue of accountability. Should committees be really accountable? And that's the one other point I would like to offer. I'm almost certain that when we get to the Citizens for a Better Ventura County, you should consider that one of the issues that they will offer as mitigation, or that should minimize their violation, is they will say, well, as soon as the clerk told me, I filed. Well, if the clerk doesn't tell them until the day after the election, you can again see everybody has a role to play. The commission has a role to play. The board has a role to play. The clerk has a role to play, and there should be a sense of accountability. It should be appropriate. We should figure that out, and the commission can help set that precedent. That it shouldn't be financial. That the commission is only going to consider administrative penalties like directives to the clerk that the commission believes this should have happened or that should have happened. That would be perfectly acceptable. My goal here is to keep making this better so that we have a better ordinance, and to establish the precedents that make it constantly a better ordinance and a better system for us here. Thank you very much.
Thank you. I think I heard a request for a continuance.
At a minimum. You could certainly, but yes.
But the question I have in my
Yeah, this is sort of stop while you're ahead.
the question I have in my mind is what benefit there is in setting it for an evidentiary hearing. As I understand it, perhaps the only evidentiary issue raised in item number 11 deals with the timeliness of the postmark and whether it was addressed properly and so forth. Other than that, the facts seem to be largely not in dispute. What I would like to do depending on how the other commissioners feel, is to continue the matter without setting it for an evidentiary hearing and request from legal counsel from both sides of the equation authority on the issue of the scope of the authority of the commission to make orders with respect to the clerk. Obviously, one answer could be that the answer is a political one. If the clerk isn't performing his job or the district attorney isn't performing his job, the next time he comes up for election will be done. Administrative mandamus is a potential. A cease and desist order is specifically authorized in our ordinance for certain violations. Is that available? And is that an adequate remedy? I'd like to see some legal analysis of those issues with an opportunity to come back and discuss those legal issues at the continued date. Any feelings about that?
I don't see any reason for an evidentiary.
I don't see a reason for an evidentiary hearing because it seems like what we're going towards is, let's assume that we were to agree that the administration of the ordinance, and as Supervisor Bennett has pointed out, it requires, prompt, timely action on the part of the clerk. And in this case, based on whatever evidence we have, we were to conclude that we thought it should be done better. It could be viewed as gratuitous advice by the elected official, or it might say, gee, we're trying to improve our administration of the ordinance too, and now that we have been through this experience, next time we'll do it better. That does, I guess that's maybe a better precedent, but it doesn't necessarily guarantee anything. So,
But that's not what the ordinance says. This is a complaint for a violation under the ordinance. And under that ordinance, if there's a violation, the ordinance says we have authority to hold him personally liable and impose a penalty. Now, we may choose not to impose a penalty. That's the problem with this ordinance, and that's why I question the validity of the ordinance. And I think that you need to go back, personally, I think you need to go back and take a look at that and come up with a remedy that meets this situation, which isn't personal liability with money damages on an independent elected official that's out there trying to do his job.
See, I'm not sure it has to be approached from that perspective anyway. We have characterized the complaints as being against Mr. Lund, the clerk himself. Oftentimes complaints are directed at public officials' offices. If this were a complaint to be construed as against the office of the clerk, then the remedies necessarily would shrink, but the opportunity to adjudicate it would still seem to be there. I would rather construe the complaint against the office rather than the individual and absolve the commission of the obligation of fixing monetary penalties, but assume the obligation of formulating a reasonable order.
Mr. Chair, can I raise an issue on that point?
I'm sorry?
May I raise an issue on that, at that point? In my view, the three complaints, allegations that have come to me for investigation don't necessarily depend on the macro issue of whether this commission can hold an elected official personally accountable. It's an important issue. I raise it in the report that I give to you, and certainly an important issue to the clerk. These three allegations, in my view, don't depend on the determination of that macro issue. But specifically with regard to your comment about construing the complaint to be against the office rather than to the individual official, in this case the complaint specifically names an individual. And so I'm obligated to investigate the complaint in light of the individual that has been named and whether or not the evidence supports a violation against that individual. And that's why that piece of it is key to the recommendations that I have made with regard to the three allegations that I investigated. So I agree there is some room definitionally in the ordinance to determine whether the office should be, whether the word clerk should mean the office. Right now, as defined specifically in the ordinance, it doesn't. And so, and the complainant named the individual. So I'm forced to investigate these matters against
But the specific
individual.
language of the ordinance does not refer to an individual either. It simply says the clerk.
But as I point out in the memo, the ordinance defines the word clerk as clerk or his or her designee.
Which is like the office.
Correct, but this complainant named an individual as having violated the ordinance by name. So I'm forced to look at the four corners of the complaint that says Robert Lunn violated these sections of the ordinance. That's how I approached the case, and that's why I made the recommendations I did.
You know, I know at least in criminal matters, it is possible, and I reach way back for this, to amend the allegatum to conform to the probatum.
Sounds like a disease.
That is, perhaps it is possible to construe the complaint against the office rather than the individual if that appears from the evidence to be what was intended or desirable.
Specifically, may I address that?
Okay?
I'll be very brief, and that is, your operating procedures, which I was just reading, specifically allows the commission to amend a complaint. So you have written into your operating procedures that ability to do that, and as the complainant, I would be very comfortable with that. My intention is not, I thought I would be caught in a catch-22 if I brought a complaint against the clerk's office, and somebody would say, well, you can't do that, you've got to have to. So I simply, in trying to figure out who it was, and thought, well, he's the person responsible for the operation of the office. But it's not my intention to focus this on an individual. It's my intention to try to get better compliance with the provisions of the ordinance in the future. So I would be very happy with that if it was amended to move that direction, and also comfortable with your recommendation to continue this so that we can get better legal arguments about what we can and can't do with the ordinance.
I'm sorry, Mr. Steele, had you finished?
Well, I'll take the direction of, I have not presented the memo at all. I'll take the direction of the commission. If you're going to continue the matter, we'll certainly wait, or if you want to hear the issues now. As I say, the identity issues and the issue of whether or not you can impose these penalties against an elected official, that's not central to the recommendations I'm making, so it's pleasure of the commission at that point.
Okay. Mr. Becker, you're here representing the clerk. Did you have a question or comment?
Good morning. I'm Jim Becker, and I'm representing Mark Lund today. I'd just like to talk a little bit about kind of this from our perspective, from the clerk's office. I think we agree with the discussion here and this issue that's kind of been raised at the 11th hour of does the commission have the authority, in particular with the actions of the county clerk's office? And I think that's a very important legal question to decide. I think what's a little confusing to me is that we kind of started this process back in November when Mr. Bennett sent the complaint in that had 5 separate allegations. That started a lengthy, very, very labor-intensive process on the part of our office to address those concerns. It then went to Mr. Norman, who came back today with recommendations to dismiss 2 of those 5 allegations. The 3 remaining allegations then went to Mr. Steele, and he has before you recommendations to dismiss 2 and for direction on the 5th. That's kind of what we were looking to see what would happen today on that. And then what's happened instead, I'm just speaking here, and this maybe just personally on the process. What seems to have happened is Mr. Bennett's now gotten up, and he has kind of at the 11th hour raised these other issues. And we're kind of, I think the discussion here has kind of lost focus. I mean, this is my viewpoint. We were going to be talking about, and I think this is what's important to Mr. Lund. The authority is important too, but probably more fundamentally is the issue of did we fail to perform our duties? And our position has been all along that we have not failed. And I think the point I want to make is if you continue this hearing and we do so, I don't want to lose sight of the facts of the case, because I think that's what's fundamentally important to the voters, is the clerk's office performing their duties under the ordinance? And it's our position that we have been consistently. And Mr. Bennett talks about things like promptness and accountability. We believe we're accountable and that we've been prompt. We were looking to this process to be prompt. A lot of time has gone into these allegations. I'm not exaggerating. I have 2 8-inch binders in my office just on complaint number 10. That's not the other 10 complaints. And we feel that the information has been presented, that the attorneys have thoroughly reviewed that, and they've made recommendations. I'd like you to consider today dismissing the 4 that have been recommended to you, and possibly continuing the other matter along with the discussion of the authority of the commission vis-a-vis the county clerk.
Thank you.
Thank you.
Do I have a motion?
You know, I have no problem taking allegation by allegation and deciding whether or not we want to act on it. I mean, if it's dismissed, it's dismissed, and then we narrow some of the issues we're dealing with. We're not changing the underlying question of authority. But I think that you know, some of these are pretty clear. What do you...
All right. Commissioner McBride has suggested that we proceed complaint by complaint under item 11. And the issue before the commission on each of these is whether or not, except with respect to complaint number 5, I take it, which is not recommended to be dismissed at this point in time. So with respect to 1 through 4, the decision before the commission presently is whether or not to accept the investigating attorney's recommendation to dismiss. Okay?
Mr. Chair, I was allowed to address Mr. Norman's recommendations to dismiss 2 and 4.
You were.
We instead focused on the question of whether the ordinance has the ability to hold the clerk responsible, but I have not been allowed to enter testimony with regards to items 1 and 3.
I think that's your right. I would note that you did submit a letter dated January 17th in which you address all of those, and the commission has reviewed each of them, so I'd ask you to limit your remarks to matters which are not covered in your letter concerning 1, 3, and 4. I'm sorry, 1 and 3. You've already addressed 4.
I've addressed 2 and 4.
2 and 4.
We're going to deal with them all.
Okay.
I think we should.
Okay. Well, I'm just asking the comments to be restricted to that which he hasn't already commented upon.
I too raised the question that if finally when Mr. Steele got to complaint 5 and ascertained that he believed that Mr. Lund should enter into some kind of letter acknowledging that there would be some improvement and that there was a problem, I would offer to you that Mr. Steele is not recommending the dismissal based on the evidence. Mr. Steele is saying he needs direction from you as to whether there is authority to go forward. If that is the position of the clerk, that he is not subject to administrative hearings of this commission, then all of Mr. Becker's arguments, I would offer, why was that not the position of the clerk before? Everybody spent this considerable time on the clerk's responses. So the clerk seems to have this going both ways, which if he can respond and get it dismissed, that's one issue, but if not, the clerk is going to assert that he has this other position. As a result, considerable time has been spent, and that issue needs to be addressed out there. I think I would offer, in speaking in opposition to this, I would offer that your original suggestion to determine the legality before you go into hearing on these particular cases, each particular complaint is the far more logical way for us to move forward. But Mr. Steele offered his, but anyway, so I want to get that said as
Well, I would suggest to you that it's not unusual for a lawyer to address the merits of a number of charges or counts
Sure.
while asserting overall a lack of jurisdiction over the entire matter. So I don't think those are inconsistent.
Okay.
And at the conclusion of the Commission's decision with respect to each complaint, if there are any remaining, then certainly we will have to address the underlying issue.
Great, and if I could grab my glasses here, too.
Okay.
With regards to complaint 1, I have identified, and I believe that Mr. Steele's arguments for dismissal that I read last night, and I would hope that we would have more time to digest before we make a decision on, given that it just came in last night with a variety of very complicated things. It's to a large extent is based on the fact that it's not clear who he should hold responsible. Is it the clerk, is it the clerk's office, etc. I am offering a remedy. I've offered a remedy here to that question by suggesting that the complaint could be amended to deal with the clerk's office. And you have talked about if that is in fact the case, and depending upon the legal hearings that you find, you may be very comfortable in terms of that being completely limited to advice to the clerk in terms of what the clerk should do based on this complaint. So Mr. Steele offered to you an argument that I was not able to make in my comments to you yesterday, and that is he doesn't quite know who to hold negligence, since I didn't have conversations with the clerk. I think that far better than dismissing that complaint, that should be continued so that we can you can amend the complaint, or you can direct that the complaint be amended, or direct me to amend that complaint based on my testimony here today that I'm willing to do that. But that is the primary reason, I believe, offered for why that should be dismissed. I think that the plain reading of 1275D and the fact that I have a letter from the clerk identifying that very report, 465, that was filed on September 26th, that I have that letter, and he uses that same report, which is not a 1275, merits that not being dismissed and that being considered pending your analysis as to whether you can do that or not. With regards to recommendation 3, the new information that that I entered, I would like to offer again. Mr. Steele, in his complaints, talked again about the issue of not knowing who to hold negligent for this, but I offer to you that the definition of promptly should have greater meaning shortly before the election, and the commission would be certainly within its responsibilities to try to make sure we have a strong ordinance by being able to give some directive to the clerk with regard to that. If you dismiss this completely, I believe you will not be availing yourselves of the opportunity to suggest to the clerk that going from October 25th to the November 7th, the day after the election, does not, from the Commission's perspective, meet the timeliness requirement of the word prompt. There were 3 reports: a September 26th report, an October 5th report, and then an expected report coming in on October 25th. That report did not come in. And the clerk has a responsibility to the public to, at a minimum, notify the people who have not filed that report to make sure that report does come in. With regards to item 5, I would offer again, Mr. Steele was trying to get the clerk to simply agree to some kind of letter about improved practices. The clerk refusing to do that, and Mr. Steele's not recommended dismissal of that, so that's not the subject of this testimony. But I believe 1 and 3 are not ripe for dismissal at this point in time, because a major reason for the suggestion for dismissal was Mr. Steele's inability to identify who should be responsible, since there are multiple people involved in this, and that we can address with an amended complaint, and that would be in the better interest of the public to air those issues out so that we have clarification. Just like you asked for better clarification for the future, we could have that clarification if you choose not to dismiss the 4 complaints at this point in time. Thank you very much.
Thank you.
I'm sorry, Mr. Chairman, we've sort of gone in different directions here, and I never actually had the opportunity to present this report to you. And I'm not here to argue with Supervisor Bennett, but I want to make sure some of the issues are correctly characterized.
Again, I would acknowledge receipt of your letter from last night. If you have items that you did not cover in that letter, would be pleased to hear them.
They're covered in the letter, Mr. Chairman. If you have any other questions, I'd be happy to address them.
All right, then turning to the issue, Mr. Oriana?
Thank you, Chair. See, I want to address just a couple issues on 1, 3, and 5, and just an overall issue on 2 and 4. The clerk's position is that everything was complied with to the best of their ability, given the information they had, which included advice of counsel from me dating back to 2009, before the election and appointment of the current clerk. I believe in this clerk's position that 1 through 4 should all be dismissed, and that even 5 should be dismissed for the following reasons. As to 1, the reason the interpretation and advice from me and our office was that a 1275A form has to be filed before a 1275D notice has to be given is the following. The words "a report" are used in both those subdivisions. Plus, there's no reason for a subdivision A report being in the same section with D unless that's the trigger point. In addition, everyone has agreed and written, including Mr. Norman, that $1,000 is the trigger for that notification. There's no $1,000 figure in subdivision D. If subdivision D is read as a standalone, a $10 expenditure would require a report. And what's important to focus on here is what happens in the clerk's office. There are sometimes 7 county races at issue. There are multiple other city, measure, and other races. These forms are coming in constantly, and they're being placed on the counter immediately. These subsequent duties require page-by-page review. For example, the first September 26th report lists $22,000, lists expenditures of $2,000 for signs. But without reviewing each page and seeing, you don't know what race that's for. The $22,000 in expenditures on the next form don't attribute in contributions, don't label those in respect to any campaign. that's a new committee filing for the first time, named Citizens for a Better Ventura County, could be dealing with any issues: tax measures, city elections, school elections, other contested races. There's no way for the clerk to know ahead of time what to be looking for. But mainly, the clerk has to prioritize his duties and his staff duties. These duties are performed at a level 4 places below the county clerk, by a supervisor 4 places below. And they go up the chain and come to me occasionally for advice. That's how the 1275 issue came. What the facts presented to me was, we have multiple forms. Sometimes there are 7 elections going on. Are we supposed to comb through each of those forms? My advice was, 1275A is in there for a reason. It requires and puts the burden on the committee to file a 1275 form, so you know to look to see if the expenditure has to be reported to the other candidates. On the other hand, just because the 1275 D duty is triggered by that form doesn't mean the clerk can't do it otherwise. In this case, as soon as the clerk became aware that those expenditures had been made, those other forms were referenced and sent to, a notice was sent to the other candidate. If you could excuse me for a minute, I've got to get some water. The clerk's position is not that he can't inform other candidates when he becomes aware of facts that require or mitigate in favor of making those reports. The question to me was, is there a duty to do it? Are we supposed to look through every single one of these forms and see if on page 9 of 12 there's some expenditure to some local race? And there could be 7 local races going on at the same time, especially in a primary. My advice constantly has been no. 1275 was adopted so that the burden is on the committee to tell you they've done that, and then, yes, you have to look and report those. They also have to keep a cumulative total to see whether that committee and other committees' contributions against or in support of one of the county candidates triggers relief from the voluntary expenditure cap. So there's lots of other things that flow from that. But that's the reason for the advice we've given under 1275A. And mainly, it's not any report in the D, it's a report. And a report is also used in A, subdivision A of 1275. If it said any report, I would have given different advice. I wished it had said the report under subdivision A, but it wasn't drafted that way. Also, when we're facing a complaint with penalties involving fines of what could be $30,000 for failing to notify someone of a $10,000 expenditure, I think when there are when there's an ambiguity and 2 possible interpretations, you can't penalize a respondent who took one of those 2 possible interpretations of the provision. As to 2, the complaint states what it states, and it says contributions, but the provision in the ordinance only requires it when there are expenditures. There's no reason not to dismiss 2. There's no reason to amend 2 otherwise, nor do I see any way to amend any of these, since by the complainant's own admission, he doesn't know who ultimately made the decisions. I don't think there are any provisions in the ordinance for discovery, but more fundamentally, and bearing on the issue of whether there's jurisdiction to have the clerk's office, which is not an individual, and the complaint structure of the ordinance is to be filed against persons or committees, not an office. If it were possible to do that, if it's possible to hold the clerk responsible under complaints, then should the initial complaint review attorney be subject to a complaint if he misses the 30-day deadline for a report? Should the investigating attorney be responsible if he misses one of his deadlines? Can citizens come in, individual citizens? Could Caroline Williams come in the day after the 30 days and file a complaint against either of those attorneys? On your agenda, you have a report that's due every 2 years from you to the Board of Supervisors. If you miss that deadline, can someone come in and file a complaint against each of you, forcing you to recuse yourselves, a new commission to be appointed to decide whether you violated the ordinance? There's a provision in the ordinance that requires you to do that. You're persons. The scheme of the ordinance is about campaign finance ethics. The people engaged in that pursuit who have to be monitored are candidates and committees, not an administrative office that's doing its best to implement the ordinance. I think you have enough on the record to take care of that overall issue today. If you want to defer it, we're happy to provide more legal argument on that. I would hope you would turn to your own counsel for that as well on this issue. On number 3, on the filing, I believe that's number 3, is the overnight mail report. I'm not switching 3 and 5. 81007 of the Government Code from the Political Reform Act provides that giving it to an overnight carrier properly addressed, and it was addressed to 800 South Victoria. We have no evidence that it wasn't sent on the date that it was stated. Means it's filed as of that date. In the ordinance, in the early sections, it says that when not specified in the ordinance, the Political Reform Act, which would preempt anyway, controls as well as the regulations control. And I can give you that. Oh, here's the ordinance. That's in 1263 of the ordinance. So there technically could be no violation under 3. It was timely filed. There was no notice to give. But more importantly, there was a slippage in time. And it's explained in detail in Mr. Lund's letter of what goes on, what's happening with those supervising officials. Mr. Chavez and above him, and before it ever gets to Mr. Lund, and these matters didn't. As far as I've been told and informed, and I see no evidence that they got anywhere above Mr. Chavez's immediate supervisors. They were working on an election that has to be timely done. It could have been more prompt, the notification, but as it turned out, no notification should have been given. It was timely filed, even though it wasn't timely received. Those things happen. It's a pity. But if you look at the last page of Mr. Steele's report to you, the letter from Mr. Lund, the last paragraph, Mr. Lund has already stated that he's going to implement a checklist procedure for future elections so these things don't fall through the cracks. The remedy proposed to you for an amended complaint has already been given. As to number 5, the same argument that was made with 1275 applies here. That structure of that section is set up that the committee comes in and says, we need to file electronically now. And then the clerk tells them how to do that. The cumbersome process that's currently in place because of the county's IT department is also explained in Mr. Lund's letter. But there wasn't a gap there or a fault on the part of the clerk. The clerk didn't know that that had to be filed electronically because they're not looking at every single statement and seeing, well, could this one possibly require electronic filing? They're counting on the ordinance to be followed by the committees. However, once they are given information that that's the case, which happened to come to a head in this case on November 30th, an immediate report of apparent violation was filed with the campaign finance staff of their failure to file electronically. They hadn't presented any of their forms yet to the clerk. They should have known back in September that they were triggered. But the clerk couldn't know, looking at their statements, that, and the clerk's duties aren't to do that. They are receiving office. They receive these forms, the state forms, and they put them out on the counter. And where a candidate or committee says, and I have to file this electronically, they tell them how to do that. On November 30th, when the clerk, in consultation with our office, determined, yes, they should have done that, the reported violation was sent out, and within an hour, that committee was asking, how do we do that? By December 5th, they'd filed their first forms, and by December 7th, they'd filed all their forms electronically. They are currently all electronically. So there's no remedy left there. The clerk's position is not that he's refusing to do these things. His position is that when my people become aware of the need, they will do it promptly, but that they can't read minds and intuit things that aren't there. For example, it was raised that there are $9,000 in expenditures on that September 26th form. Well, only 2,000 of those are identified as to any campaign. The other 7 or 5 or 7 were hiring a consultant. That consultant could be for the committee itself. It could be for the committee's work on tax measures. The clerk should not be put in the position of 20/20 hindsight saying, oh, They were intending to use that in that supervisorial race. You can't tell that from the form. So if these are going to be requirements placed on the clerk, the ordinance should be amended to clearly state where they are, and then the clerk can delegate duties and time and efficiently carry out these functions. The clerk's position is all 5 should be dismissed because, to the extent reasonably possible, he has faithfully and his designees have faithfully carried out their duties. If you have any questions, I'm happy to address them.
Any questions?
I have a couple. On complaint number 1, you referred or said that you felt that the burden for the reporting was on the committee.
Yes,
Right.
under A.
And that is the committee that is theoretically being regulated or audited to comply with the ordinance, right?
Yes.
Right. And so how do you see it working if the burden is on the committee and they, let's say for sake of argument, are deliberately obfuscating, not out and out violating, but just not making it easy to find, creating a timely problem, then where are we?
That may have been just what happened here. What happened was the other tenant came in and said, look at this form, they're expending money. They need to be complying with. And the clerk immediately sent out a letter saying, you need to file your 1275s. Within a week, I think they filed 5 or 7 1275s. Up until the clerk being told, hey, look, they're expending money. Look at this other form. There was no reason for the clerk, without having to do what I've said is practically difficult, which is assign someone to comb through every single one of these
Right.
forms to see, is there a local race in this one? So as soon as they did find out, they sent it. Another point I forgot is, it's not true that for the October 25th report, the clerk hadn't notified the committee. The clerk sent a letter on October 17th. It's in the record saying this is due on the 25th. As it turned out under the facts, they actually had, it appears, sent that in timely, but because of a mailing address problem, and I think it's because they listed political reform instead of county clerk, either the carrier or the clerk's office bounced it. We don't know which. But there was nothing to promptly notify them about. They'd been notified before the due date that they had to file that. The clerk notified them of all forms, and it put an attachment that showed all forms they have to file. The clerk wasn't trying to assist in some, campaign tactic here.
Right. Yeah, now I assume that people are making certain assumptions on their part as to motives and things, but just as a practical matter in administering the ordinance, if the burden is on the committee, or I suppose I'm understanding your argument that it's not a reasonable burden to expect that the clerk's office could do this, may not even be practical for the clerk to do it. So then is there a penalty, then an onerous penalty on the committee for obfuscating?
You have those reports of apparent violations pending before you.
Right. I mean,
For
that's
that
the
very
contention
committee,
is
for which
that
I can't advise you.
Right, but I mean that's basically the one of the concepts is that we don't necessarily prevent people from committing the crime, but once they do, they take responsibility and they are penalized in some fashion. And the question here is who is responsible, therefore who should be penalized?
The clerk's position is that and a little bit more. He will take on the burden of preparing this checklist now and trying to make sure that these committees don't let things fall through the cracks more diligently. And if the ordinance is amended to specifically specify that every report has to be followed, he'll, I think, ask for the appropriate budget line item so he can actually carry that out. Mr. Becker could tell you, Mr. Chavez, who's the main person for this, has 8 responsibility areas, many of which are impacted the week before an election. There are practical problems with what went on there. There was no bad faith. But overarching that, our basic position on jurisdiction is if a clerk were, as in other counties certain officials have, shirk their duties, the remedy is you go get a writ of mandate, as Mr. McBride raised later. You don't file a complaint under an ordinance for the very body that clerk helps and assists and advises. It'd be the same as if your staff clerk had a complaint filed against her because she didn't send a report to the investigating attorney right away. She waited a month, so then his deadline is missed. Whereas I said initially, the initial complaint review attorney, his report comes in because of illness or whatever, 7 days late. Is he now subject to a complaint and a sanction? I don't think that's right. The structure of the ordinance is committees and candidates are held responsible by the complaint procedure and the process before you, and that's what you're looking at. You're looking at campaign ethics by committees and candidates. And Mr. Lund, certainly as a candidate, would be subject to complaints, but his office shouldn't be a respondent. I have a real trouble with the idea of amending a complaint to have the fuzzy idea of an office be a respondent. Respondents are people who do things that are held accountable for it.
The office is a participant in the election process. They run the election.
Certainly, just
Is it
as your staff
position
does.
that a required document addressed to Santa Claus at 800 South Victoria Avenue is properly filed?
No, that clearly wouldn't be.
Is there any division of the County of Ventura known as political reform in the mail office or otherwise?
No.
But you still maintain that it was timely filed?
Under state law, because the address was correct, there's at least an argument. That actually is going to come before you, or could come before you in another complaint area against that committee. But my point is only that the prompt notification would have been a nullity in that case.
Well, that...
I'm not saying that
This happened
something
on-
slipped through the cracks that shouldn't have. That's not the clerk's position. And the last page of Mr. Steele's report, the letter from Mr. Lund, shows he's going to implement a procedure to make sure things like that get those follow-up calls. The issue is, was there an actual violation in this case? Or was there any harm? They had already sent the report.
The report was due on the 25th, a Friday. The election was the following Tuesday.
No, I don't think that's right. The
Right,
report was due
25th,
about
26th.
10 days before the election.
I'm sorry.
12 days before.
And notification of the failure to file that wasn't made until after the election.
No notification was made. It was received. By the time they got around to actually following up after conducting an election, there was the report.
After the election.
Yeah, November 8th.
The 1275 reports contain a blank for identification of the candidate opposed or supported, don't they?
Yes.
So that information should be readily available to the clerk.
Oh, absolutely. And when the 1275 forms were filed, the running totals were calculated, and a notice was given to the candidate that the opposition side had exceeded the limit, and he was no longer subject to the campaign limits. All timely done.
I have a question. On allegation 1, you've advised that the state form 465 doesn't trigger the 1275D requirement.
That it doesn't mandate.
It doesn't mandate it.
But
They
if
can
you
look
have
at
that
it,
information, you're
but
free to.
it doesn't establish a duty. In allegation 2, the claim is that a 460 form.
But the claim in 2 is that contributions were
No,
triggered.
I know, but that's
Okay.
not the issue. The issue is a Form 460 was received. Did you advise that the Form 460 doesn't trigger a 1275D notification?
My advice is different. My advice is, if you get a 1275, there's a mandate for you to notify the candidates.
Right.
If you get other information that permits you to do that, you're free to do it.
But you're not, but there isn't, the filing of the Form 460 doesn't create a duty.
No, you don't have to review Form 460s to determine whether you have to comply with 1275D.
Even though the Form 460 reflects contributions of
And-
$31,000.
And you're free
And
to do that
expenditures.
if you have the time and resources, but you're not required under the ordinance.
But the argument as far as duty is the same with the 465 or 460.
Only the 1275, in my opinion, A form,
Okay.
requires you to make that notification. If you get independent information that those expenditures are going on and that a committee is failing to file their 1275As, my advice would be, yes, you should make that notification. But that's exactly what happened in this case. As soon as they got the information from the opposing candidate, look, at all these expenditures are being made, they checked it out and made the notification, which is part of what the complainant is protesting today. They're saying that the clerk acted inconsistently, The clerk's position is that only when I get a 1275 will I make that notification. That's not the clerk's position. The clerk's position is when I get 1275As, I will look and make those notifications, but I'm not combing the other reports to look for the same information. If I find out, I will make the notification. But that's not exactly a voluntary thing, but that's a thing that's triggered by other events. He's not going to withhold notifying because he didn't get a 1275A, which is what happened in this case. He did notify.
Okay. Anything else? Okay, Mr. Bennett.
I beg your indulgence, but some testimony has been entered that I think needs to be corrected, and that is it deals specifically with complaint number 5, and you don't have a recommendation to dismiss from either of the attorneys at this point in time. The clerk is arguing that you do. Part of the reason the clerk is arguing that is they say as soon as they knew the committee had spent more than $10,000 on November 30th, they notified the committee to file electronically. That obviously has not been an argument that's been strong enough to compel either the investigating attorney or the initial review attorney to dismiss. I would offer that shouldn't be an argument that's strong enough for you, particularly because of this fact. On or about October 25th, the clerk, as a result of my urging, did finally send me a letter letting me know that I no longer was bound by the voluntary expenditure limits because the threshold had been exceeded by a combination of the citizens and the firefighters. And they had done a calculation of how much money Citizens for Better Ventura County had spent in this campaign. And that calculation was well over $10,000. So the clerk, it's being portrayed here that I am suggesting the clerk has to stop and go through everything over and over again. I am suggesting that when the clerk does have the information, and the clerk did, and I did say to the clerk, and that's one of those things that's in dispute that the clerk says, well, when I obviously raised these issues. But the clerk had calculated that. They didn't have to go through and find anything else. They had calculated to the point that they sent me an official notification that I didn't have to do that. And yet the clerk still did not notify the committee that they had to file electronically. Now, I think that is at least should give you pause and not accept the idea of dismissing that allegation number 5. And I just want to correct that. I think it's... The reason I'm here, if the clerk would have promptly, with each notification, taken action, I would not have filed a complaint. But I believe that the clerk did not take prompt action consistently when notified. And that is why I would encourage that these not be dismissed until we get to the other issue in terms of this being heard. Thank you very much.
Okay. Right. As I understand it, we had a request for continuance, and 2 commissioners wanted to hear the complaints item by item instead of continuing the whole matter. Is that correct?
Yes.
Okay. So I guess that presents us then with the question of the request for dismissal of complaint number 1.
Allegation number 1. As it's
Allegation
called.
number 1. I'm sorry. Sometimes they're referred to as complaints, sometimes they're referred to as items, sometimes they're
Allegations or whatever.
allegations, yeah.
I struggle with all of these, and I appreciate very much the input that we've received from everybody here today. I think it's as painful as it has been, and I know especially for the clerk's office, I think it's valuable to go through this process. Where I'm coming from on allegation 1, and I believe on allegation 2 as well, is there has to be an intentional or negligent violation. And when counsel has advised the clerk that they do not have a duty to review those state forms, I find it difficult to say that they intentionally or negligently didn't file the notification. So I guess where I'm coming from there is on that grounds, a dismissal of allegations 1 and 2.
Okay, that's a motion. Is there a second?
Yeah, second.
All right, I have a problem with the dismissal of 1. Understanding that counsel did advise his client that the 1275 form was required, it seems to me that there was enough information available to the clerk and information that the clerk was customarily used to considering in connection with the amount of expenditures and the use of his use of the same form to identify the expenditures leads me to believe that the failure to notify within the 24 hours was at least negligent. So I would vote no on the dismissal, but it carries 2-1.
Well, wait a minute, I just second the motion.
Oh, I'm sorry.
We haven't talked. I wanted to ask the question. I've heard an expression on the part of just about everybody, in particular Mr. Bennett who filed the complaint, that the goal here is to improve the process, not to penalize individuals. And I'm trying to, and I personally agree that should be always the goal. But we have a combination here of charges leveled against individuals with the possibility of penalties to be assessed as one means of kind of coercing better performance in the future. But that's not the only way to do it. And in the past, we have sort of, updated, closed loopholes, whatever you want to call it, to improve the process. And the complainant's concern is that if we dismiss these things, that somehow we are setting a precedent and setting the process back, which is potential, depending on the facts, but not necessarily. That it seems like we're talking about two different things. One, to improve the process, and the other is to, what do we do with all this procedure that's before us? And it seems to me that in many of these cases, I would agree with Commissioner McBride, that if the investigation and what we have here does not conclusively show, deliberate, negligent, or intentional action on the part of the person or the office being accused, it's really hard for me to see how we get to the point of doing something and then say there's going to be no fine involved. But I also can't see getting to the point of saying, yeah, we're going to fine people on this. I'm perfectly comfortable with the idea that through this discussion, as has been pointed out, that we brought out a lot of good points or things maybe that weren't thought of before. I know this doesn't address motives and maybe what anybody intended to do, but based on the facts, it seems like we do have some gaps, and there is certainly a persuasive argument that the burden on administering something like this is extraordinary. And while it's not impossible to measure up to the burden, the amount of time and money, taxpayers' money, that goes into all of this in the greater environment of trying to solve this problem of money in politics, which is not just in Ventura County, in the state and in the nation. I'm trying to figure out a way to sort this thing down quickly and focus on actually improving the process rather than to argue over, whether someone intentionally did it, because we can't go back. And so I guess my conclusions were, what is the remedy if we're not going to fine people and coerce them, which I don't think the process really provides for, not effectively, or what is the harm done if we dismiss some of the complaints with the proviso that the information we're gathering from this is that it gets tightened up. Already the clerk's office has committed themselves to a checklist and to doing better in that regard, and in some instances it appears the ordinance itself needs to be amended if we're going to hold individuals responsible. And we need to get our head around the idea that if committees are responsible for this, the only way that works effectively is to have something that's fairly significant and not a $700 slap on the wrist to people who clearly are engaged in circumventing the ordinance. So, and having said all that, I guess I'm wondering, what is the harm done with the dismissal of some of these? Because if there is harm, then I certainly don't want to see us just push it aside. But if there's nothing to be really gained other than I'm right and you're wrong, then that's not necessarily advancing, the policy. So
I agree. And obviously, failing to dismiss this matter will activate the remaining issue of jurisdiction over the clerk and what appropriate remedies can be fashioned and so forth. And that's probably something to be avoided if possible. I don't ascribe any ill motive to the clerk in failing to make the required notification. The clerk and clerk's counsel is familiar with the ordinance, and I find it, I disagree with counsel's advice that only a 1275 triggers the obligation. I guess reasonable minds can differ about things like that. So, I guess,
Well, the underlying issue that the clerk has to wrestle with, and we all have to wrestle with, is the scope of the obligation the ordinance puts upon the clerk. And I'm guessing that the one extreme is that the clerk is obligated to look at every single filing that comes in, read every page, extrapolate how it's going to impact on county office candidates and issues, and take action. That's an extreme.
it is.
The other is that he doesn't look at anything. And that's the extreme. And I don't know how you figure out exactly what's enough. I think in these two instances, in my view, if we're looking at an individual who's trying to make a decision and counsel tells him, you don't have a duty to do that, then how can there be a violation if there's no duty? It's a very technical argument.
Well, this isn't specific to complaint number one, but just to acknowledge one of the issues facing us as a society and a political environment, that the positions of Secretary of State and the positions of county clerks have taken on a new significance and role throughout the nation as to exercising their discretion with regard to, early voting and all sorts of things. But that is a much larger political issue than what I think this commission is capable of grappling with. I think we should recognize that is without accusing anybody of anything, but it is a concern. But it is a concern that would normally be dealt with at the ballot box by voters supporting their elected officials because they had acted in what is believed to be the best interest of the community. Trying to nail this down, it seems to me, if we're going to hold individuals responsible or find things, we just have to be really precise in what it is, and where if there's some of this can be amended and makes the case stronger, maybe so, but based upon what our investigators were given and the facts that were given, it seems like some of this we could set aside and devote our more attention to say, now what are we going to do for the next go round to make it more responsive and have the clerk's office get the resources maybe they need. If the board adopted the ordinance, and they should maybe be having the discussion as to how much money they are willing to devote to this to be sure that it's comprehensively handled.
The ordinance does go to some lengths to point out what the duties of the clerk are. I'm just frustrated that the intent of the ordinance was to allocate responsibility in a particular fashion. And we're saying that unless it's intentional or grossly negligent, that division of responsibility should not be observed. but that may be a necessary evil. Maybe the ordinance needs to be amended to provide for some sanction or remedy or clear delineation of mandatory duties. I don't know. So I guess we have a motion on 1 and 2 to dismiss. All in favor?
Aye.
All right. I'll vote aye as well.
Well, you have another comment to be made regarding this sort of thing. It's maybe a little bit homespun, but, there's an observation that the first time something occurs, it's considered to be an exception, and the third time it occurs, it's the rule. And I think part of the way in which we view these things, if it happens one time, maybe there's an explanation. If there is a persistent pattern, then I think we look at it differently.
Okay. I guess that puts us down to item number 3, which is the failure to notify this is as a result of the failure to file and notify.
This is the FedEx.
I'm sorry?
This is the FedEx, isn't it?
Yeah. Whether or not it was actually timely filed by virtue of having been placed in the Federal Express, addressed to political reform at the county address. Any discussion about that one?
The consequence of that was because of the lack of timeliness. Did that affect the, I think it said something here about the campaign?
Yeah, the report was due the 25th. It wasn't filed until the 9th of November,
After the election.
after the election was over. And I presume that deprived the other candidate of the opportunity to point out whatever details he or she thought were salient in the missed report.
And the fact that it was filed, if you accept the idea that when it's dropped in the post office or handed to a carrier, that is, I guess that's the legal question. Is that in fact...
It's kind of two questions, isn't it? I mean, the committee screwed up by misaddressing it or failing to address it appropriately.
Although
And
I still don't understand why it wouldn't have been delivered.
that is
I mean,
puzzling.
But it wasn't, but the address was that far off.
Yeah, but the other potential violation is the failure of the clerk to demand the filing of the document. I guess between the two, I find fault lying primarily with the committee, not the clerk. So there is a motion to dismiss complaint number 3. I'm not satisfied that it was timely filed.
There isn't a motion.
There isn't a motion? Oh,
There's no motion on
I have a motion on 3?
it. No,
No?
we're just talking. Go ahead. I'm sorry.
No, that's right.
You were
I said what I
making-
wanted to say. Is there a motion on 3? Does anybody want to make a motion on 3?
Yeah, I continue to have difficulty with the idea of where you place the responsibility or the accountability. If it's placed with the person who benefits from the mistake or the confusion, that seems like a guaranteed way of getting more confusion that benefits people who deliberately do so. But that's a separate question from the complaint is against the clerk, saying that the clerk has an obligation to keep track of who's delinquent. Is that correct?
I think if I understand the argument, is that the report should have been received on the 25th. It wasn't, and there was no notification that the report hadn't been received. for a period of
2 weeks.
10 days, 12 days, whatever it was. And the argument is that whether it should have been in the mail or was in the mail or whether it was technically filed, the clerk didn't receive it. And should the clerk have recognized that before 10 days was up, or 12 days was up, and given the importance of the election issue and all that?
But the clerk had notified the committee on the 17th that the report was due on the 25th,
Right.
prior to its due date. The clerk did send notification to the committee that the indicated report was due on the 25th. So,
Okay.
again, primary responsibility appears to be with the committee, not the clerk, but did the clerk satisfy its responsibility to review the documents and determine their sufficiency?
This sort of takes it down to that question of, when you say, oh, were you prompt? And you can be prompt and not be timely because of things beyond everyone's control. There was an election held. If they were notified a couple of weeks ahead of time, or what was it, 12, 14 days ahead of time, and they didn't do it, the penalty, I would assume, would go against the ones who didn't do it. In this case, that would be the committee. The clerk's action to say, you're delinquent in getting the report in. Beyond that, what does the process expect? Because it's so close to the election became the reason it had the impact.
But what would have been the result if they had notified them on the 27th that the report hadn't been received and they still didn't send it in?
Doesn't guarantee that it would have been received
Don't
by
guarantee anything.
the election.
But it would be certainly more, I would think, more of an onus on the office that if you're telling them it's delinquent after the fact, as opposed to, reminding everybody get your homework in. I guess I don't like the way it came out, but I don't see how there's any kind of maliciousness or
Negligence.
on the part of the clerk's office.
So the recommendation is to dismiss. Is there a motion?
We have 3, 4, and 5 left, is that right?
Three.
We're on 3, but we have 3, 4, and 5 left. I guess my reluctance to just jump in and say let's dismiss is that I'm trying to understand the procedure and legal process by which we'll be sure that this doesn't just say, well, sorry, you didn't file this to our satisfaction, so it's all dismissed, not to, sort of without prejudice, but are we going to, is there
Are we going to get to the bigger issue?
And will that, when do we, is that 5?
I think we have to get to the bigger issue, but I think my view is we get rid of some of these, in my view, a little bit smaller issues and deal with them if we can.
Do you consider this one, say, lesser than the...
Well, I don't know if it's any lesser, but...
There's an additional uncertainty in this one, in that the requirement is to promptly notify. Promptly is otherwise undefined in the ordinance. We have no regulations interpreting our ordinance, so it may not be a lesser matter, but it's a more difficult one to
Kind of like the
prove.
first two, I view those as kind of technicality as far as intentional and negligent.
The dates by which this is due, like October 24th or 5th or whatever, to October 25th, that gets set how? It just sort of seems like that particular date when you have elections that are like a week later
I
or
think
2
that
weeks
is-
later, that it will always be a problem for the final report, will it not?
But all those final reports are scheduled that way. It's the final report prior to the election
It's going to be close enough to the election
to be meaningful.
to
Right.
cover everything.
Okay, so anybody who chooses or negligently forgets to do it, that there should be some consequence to
It's a big
them.
deal.
I'm not sure what can the clerk's office do to, other than call all the other candidates and say,
Yeah, this doesn't
What's the
trigger the forgiveness of the campaign spending limits and so forth. It's simply a requirement that wasn't adhered to.
Yeah, okay, well, okay. If you're reluctant to have your name on all the dismissals, I'll move to dismiss it.
Second? Any objection? Hearing none. Item number 4. This is the one concerning the duty of the clerk to review the forms and determine their sufficiency. And the complaint addresses itself to some of the 1275s that were filed, and is that the right one? Yeah.
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 But look in their face, whether they conform on their face.
And if you look at
Whether
the
it's
series
readable.
of the expenditure reports that were submitted, they were noticeably deficient in terms of failing to indicate who the candidate opposed was, having the date instead of the dollar amount, which arguably reduces the effectiveness of the report considerably to opposing candidates and so forth. But the issue again there is not whether or not the committee ought to be held responsible for these delinquencies, but whether the clerk in his responsibility to review and determine the sufficiency of those filings was violated.
This
1298 provides that the clerk shall supply the necessary forms and manuals, determine whether the required documents have been filed, and if so, whether they conform on their face with the requirements of the ordinance, and notify promptly all persons and known committees who have failed to file a report or statement in the form and at the time required by this ordinance.
That gets down to the question of what kind of a duty is being placed on the clerk. To what extent? And that's the same with all of these. How much effort does the clerk have to put in? How many forms does he have to review? How much does he have to go in the content? And what does the ordinance mean when it says on its face? Conform on their face to the requirements.
This is sort of a debate between the clerk's office and the Board of Supervisors on their ordinance as to what extent do you go to be an enforcer of the rules as opposed to just administering the rules. If people, you can tell someone you have to do it and there's a law that you have to do it. It doesn't mean that they will do it. And so you have an administrative body that, tells you what the law is, then you have an enforcement body that goes out and, executes the law. I don't know that there's, according to the investigator and in the ordinance, I don't see how the clerk can make the person file a clear copy, but there should be some sort of penalty for failure to, if it is unreadable, how is that in compliance with the ordinance? I don't know if that rises to the level of an apparent violation.
Well, the evidence appears to be that it was legible. on that
Well,
issue?
there seems to be a dispute over that, but the investigator said I didn't receive evidence that it really was illegible, right? Yeah. So we didn't find that to be the case, but let's assume it were the case. What is the obligation then of the clerk's office to, other than to keep the records and allow whatever penalties to be imposed for failure to comply?
Well, the obligation apparently is to notify the submitter of the report. 1298C, notify promptly all persons in known committees who have failed to file a report or statement in the form and at the time required. And then you have to determine whether the documents have been filed, and if so, whether they conform on their face. I guess if they don't conform on their face, then you might read that as being an obligation to notify them that they don't conform.
Did they never?
And then
Well, this is where the complaint is fairly clear that there is a belief on the part of the complainant that the clerk's office is deliberately not enforcing the ordinance.
yeah.
But the investigation didn't support that.
Well, if we are interested in having a resolution of the underlying issue, this is one of the matters that Mr. Bennett has indicated he would amend to allege a more appropriate respondent, and maybe that will lead to a resolution of the propriety of sanctioning the clerk as an office, which is what we wanted to know.
Was this the one he was going to?
Yeah, 2 and 4.
2 and 4, yeah. So you're suggesting?
I'm suggesting we not dismiss it, allow...
Just let it.
Oh, I guess we can go ahead and dismiss it without prejudice. Is there such a thing as dismissal without prejudice of these complaints? And would an amended complaint be timely at this time?
I think the ordinance is silent as to your ability to dismiss with or without prejudice, so I would say that you, within your discretion to dismiss a matter without prejudice, allowing a respondent or a petitioner to file a new complaint clarifying issues or following direction, what have you.
Assuming that to be the case, I would...
Well, procedurally, is there a difference in the amount of effort on the part of staff and on the complainant to amend as opposed to refiling?
Would the amendment have to go back through the process?
I would assume so.
It would be the same thing? Is that what you're saying?
Somebody has to make the determination whether or not the amendment is material
Right.
and whether the investigation is applicable to the new complaint. So I'm assuming it has to go back as though it were a new complaint.
Which I'd rather find a way not to do that. I'd rather get these resolved.
Well, that should be fairly truncated, don't you think?
Commissioner, may I direct the Commissioner to the Standard Operating Procedure, Section 1305, Amendment, Dismissal, Motion Practice.
I'm sorry, the section again,
13.05 of your operating procedure.
1305 suggests that it must be by motion, but I'm assuming that if it is acceptable to the parties, we could simply grant leave to amend the existing complaint. What do you think? It just has to be filed 14 days.
14 days prior to regular scheduled meeting, so.
February 22nd?
There may be a problem with that date. I'm fine. I don't know exactly what the amendment would look like, if it's just more specific details, or is it the same allegation? This one, a report was filed, it was allegedly incomplete, and that was the violation. It didn't conform on its face, it wasn't legible, readable. That's the complaint. Now, is that going to be changed, or simply added to, or clarified, or what? If you can speak.
Go ahead.
Thank you for this opportunity to try to clarify. There were, as was reported, after notifying the clerk of this duty, a number of 1275 reports came in. The early 1275 reports that came in were very incomplete and were not accurate. I submitted those as evidence to Mr. Norman in my complaint against the committee. I did not submit those as evidence and identify those in this particular complaint with item 4. But that is, I simply for the I would submit those very specific 1275 reports that were not complete, that had things like the date listed where the amount was supposed to be, as evidence that they were not reviewed on their face in terms of that. If I could, while I have you, I know a number of times you brought up, well, if the clerk notified them, it still doesn't mean that they would do it. And I would offer to you, particularly in the comments that I've submitted with regard to number 5, which is still coming up for you, but it relates to number 4 also, that if the clerk timely notifies, then you're right, the committee may still be reluctant, but two things happen. Either the committee will more promptly respond, which is good for the public, or when a complaint is filed against the committee, the penalty can be more severe because the committee delayed after being notified from the clerk. So that is why there is such a special responsibility for the clerk to review and notify promptly. It's so that when we are sitting here and when the investigating attorney is trying to determine what the appropriate penalties are, you have a better chance of determining, hey, this committee was really intentionally dragging their feet because they knew time was everything. Once the election was over, it didn't make a difference what was going to happen. So I'd offer to you that is why there is this provision, and that is why we have to be careful about decreasing the importance of the following through on that particular provision. And that's why I would be willing to amend the report, and I believe that the operating manual gives you the authority to amend the report. I suggested that same thing for item 2, and I think that comes down to your belief about the 1275. But this is even more important, which is the clerk's duty to review the forms and on their face quickly notify. I mean, at the time that the form comes in, if the date is listed there, the clerk has to stamp that report. We talk about all of these reports, but that's a report that's handed to the clerk and stamped. And reviewing something like, is the amount listed where the amount is supposed to be, knowing that that is a very important report because the clerk has to use it to make his determination, as well as the candidate has to use it to make their determination in terms of threshold amounts. I do have one other thing that I think is important regarding item complaint 5, and I'm happy to wait until you get to that if the chair would indulge me in terms of presenting that. But
Let's deal
if
deal
not,
with 4 first.
what's that?
Let's deal with 4 first.
Right. Okay. Thank you very much.
So what kind of a motion do you need to leave to amend, or what?
Well, the section reads, except when submitted by stipulation signed by all parties, notice of a motion brought pursuant to this section, along with all moving papers, shall be filed with the commission and served on all parties at least 14 calendar days before any regular scheduled meeting of the commission at which the motion is to be heard. Basically, we're authorized to allow amendment of a complaint or a dismissal, or all or part of a complaint. So we would be allowing amendment of a part of P-10, or the 5-part complaint. And if parties here today, it says stipulate in writing, doesn't it?
This is in lieu of dismissal and refiling a complaint?
Well, if I understand it right, this complaint concerned an October 22nd filing of a 1275, a specific filing.
Actually, there were several. Oh, the complaint itself?
The complaint itself, I think, refers to one, and if I understand it right, the proposed amendment would be to introduce additional 1275 filings, which would allegedly, apparently show some negligence in dealing with those other filings.
The 1275 complaint that was submitted demonstrated that the committee was showing a declining total expenditure, and the cumulative expenditure of the committee is a very important thing to determine because that determines whether the threshold showed a declining total expenditure. And I offered that as evidence of the clerk needing to review on their face. They have pointed out that they don't have to determine accuracy. I would offer to you that if a total is going down as the expenditure is going up, that's illogical and would on its face. But there are other 1275 reports that clearly do not show that the form was filed appropriately on their face. So that's why I was offering to amend both 2 and 5 to correct the things that were cited. Particularly in 2, what was cited is that my complaint simply did not list expenditures. It only listed.
There's more than one 1275 filed on October 24th, right?
There,
22nd.
but in the course of a number of those days, there were multiple 1275s filed.
Okay, and you would amend to append each of those documents?
But I would amend, and I think it would be germane on the committee. The original question that I think we talked about here, which I think is the more appropriate way, is assuming that the committee feels that we have some authority here with the clerk in terms of doing that.
So you'd amend the respondent and the documents violated?
Say that again.
You'd amend the description of the respondent and the documents?
That's correct. Try to do that. And the same thing if the respondent needs to be amended in number 5, which neither attorney is recommending for dismissal, I would be happy to amend who the respondent is so that we don't have the issue of personal liability. being
The only thing
raised.
that's giving me
Still
any
got the
pause is that Section 1305 describes a procedure for amending a complaint or a dismissal, and in the absence of a stipulation by all parties in writing, there has to be 14 calendar days notice and so forth.
Okay.
I'm trying to think of a way to short circuit that.
Well,
One way would be simply to dismiss the complaints specifically without prejudice, and just allow you to start the process again.
And that would be acceptable to me, particularly if the recommendation in item 5, the recommendation not to dismiss is followed, and you choose to.
That obviates the need of getting written stipulations from everybody.
Yeah, so I'm happy.
I'm talking about 4 right now. You want to address 5?
Well,
So anyway,
Before you adjourn on number 4.
I'm sorry?
May I be heard on number 4?
Yes.
yeah. So anyway, so I am fine with that, which is to dismiss and without
understand.
prejudice, and I can simply.
this,
I believe the recommendation for dismissal without prejudice is better than an amended plea. But just so that you are aware of this, the complaint that we're dealing with, number 4, involves 2 reports, both dated one October 20th and the other looks like October 28th. And the only complaint was that in one column there was a cumulative dollar amount, and it was less on the second report than on the first report. So someone would have to look at this, compare the numbers of the 2 reports, or go back and look at another report to determine the accuracy or inaccuracy of this figure. So that was the reason for my recommendation that the clerk did not have a duty to go into that detail to determine whether the arithmetic is correct or guarantee the dollar accuracy. So this particular violation or allegation did not involve erroneous dates and that sort of thing. It just had to do with a cumulative total. Thank you.
and factually, we're talking about the obligation of the clerk. I have trouble if we're going to require the clerk to line up the reports and study each one and see where they're going. I mean, at some point, you make the whole purpose is public awareness. You make the documents aware. Opposing candidates can come in, look at them, do whatever they want with them. But how do we determine the scope of the clerk's responsibility? And if we amend it, all we're going to do is have other examples like this particular one where you've got a decreasing amount shown or declining when the expenditures are going up or something. I don't know that it's going to get us anywhere to amend. I mean, people want to do it, that's fine, we'll look at it, but I'm not sure it's going to get us any further along the road.
I don't know if it's going to get us any further. I have to say I'm a little bewildered with all of the leave to amend and the procedure, legal procedure, but I was hoping, I would like to clear this stuff off the desk, so to speak, because in many cases, I don't think it's going anywhere, but the underlying issues that it represents, wouldn't want to see, get away from us if there's an opportunity to do something.
I have the 2 1275 reports in front of me as part of the exhibit.
Which exhibit they are, or their
Yeah,
attachment?
11.0A here. This is the date from the 22nd. This is the one from the 23rd.
Proposed by expenditure. That's a different, but that's a different expenditure. Amendment expenditure, there's no expenditure. This one is this expenditure.
And total cycle to date, presumably in favor of, and that is blank, but presumably is in opposition to. I don't know.
I don't know.
Did you find him, Johnny?
No, I didn't.
Go ahead, it's in,
There you go.
Which attachment is that? Exhibit A here?
It's in attachment 11A.
I'm in Exhibit A.
Yeah, and there are two
11A.
75s. Wednesday, the 22nd.
Sorry about that.
Wednesday, the 22nd, and the 23rd. So the issues are, single election totals change. There's no need here. Is it the same as the one above?
Now that I've seen it, I'm not sure what it means, to be blunt.
To be blunt.
There it is. What does it mean?
So it appears to me that the issues are those two filings so incomplete as to be a violation of the required filing? Is the missing information critical information? It's hard to tell exactly what's missing. Mr. Norman, do you have those in front of you?
I sure do.
Okay. On the file, the one filed October 22nd, 2012,
Yes.
the 1275 form requires the identification of the candidate supported by the expenditure or the county, or the candidate opposed by the expenditure. The one on the 22nd appears to be an opposed, expenditures to oppose a candidate. And the total listed is $34,139.
Yes.
Okay. That was a $6,000 expenditure for something. Mailer. The one for the 23rd is apparently an expenditure in support of a candidate, Bob Roper.
Yes.
And the amount of the expenditure is, cumulative total is $4,637.
On mine, it's $31,007.74.
That's the next line down, but that's under the section dedicated to the opposition expenditures. If you look at the supported expenditures above, the amount of the cumulative election cycle to date is $4,637
Oh, yes, I see that.
in support of the candidate Bob Roper.
Yes.
I assume that the identification of the candidate opposed should have been listed as Steve Bennett, but it was left blank.
Yes.
So there is no inconsistency in terms of arithmetic between the total,
Yeah, there is.
well, 3 to 4, 41.
One has
Yeah,
cumulative
3,000
total under
less.
the opposition is 34, and the other one's 31. The question is, does the clerk have to go through this with every filing? What we're doing, trying to figure it out.
Right.
Well, no.
What if the numbers were
Now-
logical, but it's still inaccurate?
I don't know about the
What would-
cumulative, but
Well, it's kind of interesting because the amount of the expenditures for both supporting the candidate and opposing a candidate are the same on the 23rd filing. It's hard to imagine how you do that.
double reported. I don't know.
What is the practical, or the implication of this? Let's assume that the clerk had identified that, and they would have then done what? raised a question to the candidate or the committee that it seemed inconsistent, they need to review their math? Or is it, was there some advantage gained by, say, underreporting by reducing the amount of money? And let's just say it was an honest error. Did they get any advantage out of the honest error? I'm just trying to figure out, well, what is the long-term gain on this other than a technical violation?
Well, the disadvantage is to the opposing candidate that they're obfuscating the amount of money they're spending.
Right, but
and that affects his campaign.
Right, but in regard to the threshold or whatever, or the spending limits, isn't that what part of this is
Right.
aimed
I
at?
don't think it makes any difference.
It doesn't seem like the difference, I don't know, maybe it's...
That's 25% of $168,000 or something like that. That's not being met.
I guess I'm wrestling with the question, aside from who's responsible for doing it, what is the real-world consequence of each of these things? Because there is a consequence in some cases. In other cases, it just is a pattern of, potentially a pattern of behavior that's being concerned. But as an individual complaint, what does this mean in terms of the clerk's performance?
Good question.
Anyone have an opinion?
Well,
or
I mean, the code says you determine whether they conform, and then you notify if they don't, if they haven't filed or they don't conform, and then you report violations, apparent violations.
Where are we?
I guess on its basis is subject to a demur. That's what the real issue is.
Well, that's the function of Mr. Norman,
Right, and that's what he's
and he's
saying.
recommending dismissal.
He's making that argument.
Well,
We have-
I move that we dismiss without prejudice number 4. Whether that encourages...
Wherever it goes.
I'm sorry?
No, no.
Whether that encourages Mr. Bennett to file an amended complaint or not, I do not know, but I don't want to foreclose it.
One second.
Any objection? Number 5. I'm sorry, Mr. Bennett, you wanted to be heard one last time, and
I think we continue this.
this is the one we continue?
I think so.
Thank
The issue will-
Thank you very much. On number 5, as I pointed out, neither of your attorneys are recommending dismissal. The clerk did have, as you just saw, the 1275 reports filed in around October 22nd that identified $34,000 worth of expenditure. That was specific to the supervisor's raise. And so the clerk was well aware, did not have to do any separate calculations, didn't have to do anything else, knew that more than $10,000 had been spent. And the clerk was also aware that they was not filed electronically at the time. The clerk, Mr. Johnson asked about the real-world examples out there. To help the commissioners understand, daily, candidates who are under attack from independent expenditure committees are trying to monitor to find out when the threshold is exceeded so that they know that they can then spend more funds. It makes a big difference in the campaign. That's the real-world example. And that's why not everything has to be checked. But this issue of how much is being spent by independent expenditure committees is important daily. And because it's important daily, the electronic filing, once you've reached the $10,000 threshold, is really important, because otherwise you require candidates to come from all over the county to try to see what might be filed in paper. One. Two, if you don't know the name of the committee doing the expenditure, which was the situation September 26th, You can't even, I mean, you would have to go through and start sorting through every one of those, which is unrealistic. The final thing I would just offer to you is one that's separate from the legal requirements here, but I do think is probably important because I hear the commissioners, because in hearing your testimony, I think it is very important, for the public to have confidence that the clerk is going to interpret these ordinances neutrally for all candidates. I think that Tim Hurt, when he wrote about campaign finance reform, specifically, I remember him writing about how important it was for the public to know that their testimony was going to be receiving as much credibility as the testimony of the person who made a major contribution to somebody's campaign. And if that contribution was too large, then there was a problem. The same thing is true. The clerk has an important responsibility. That's what the clerk, when the clerk runs for the position of clerk, it is a responsibility to administer all of the rules associated with the election. And one that is both a state rule and one of our ordinances is this one that we've been talking about, and that is to, review the documents on their face. But I should have the same confidence that Mr. Lund would interpret these ordinances and his responses that Mr. Roper should have if the circumstances were reversed. And I would just offer to you that although it's not a legal document, one of the things that certainly clouds or decreases my confidence that Mr. Lund was willing to interpret these things is the fact that early in the campaign, when both of us, Mr. Lund did what I think is a very inappropriate thing and something that clouds the perceptions of Mr. Lund's interpretations. He friended Mr. Roper's Facebook page. Now, that's not illegal. He has the right to do that, but he didn't friend my campaign page, but he did friend Mr. Roper's campaign page. After the buzz went out in the social media community about that, he eventually took that friending off. But I would offer to you that is the kind of thing, along with constant identification of things that should happen and constant interpretations of what the word prompt means and constant interpretations of we have other duties that we have to do rather than do this. But getting the electronic notification online would have made it much easier for me and the rest of the public to monitor what the Citizens for a Better Ventura County was doing. Mr. Lund knew about it, and it at least raises the question it raises the question that you take all of this evidence together, the September 26th filing, the October 5th filing, the October 25th failure to file, the electronic threshold of over $10,000 being reached, and Mr. Lund being well aware of it, or Mr. Lund's office, or the office, I should say, being well aware of it. That's a pattern that I think does make it important for us to ask the question, do we have the ability to hold the clerk accountable? And therefore, I believe this should not be dismissed, and instead, we should determine not be dismissed because neither attorney recommends that, and it would give us the opportunity to find out just how much accountability can or should we have with the clerk and the ordinance as it goes forward. Happy to provide you with evidence of the Facebook posting if that is important to you. I have it here. Again, it's not a legal issue, but it is an ethical issue.
Sure. Mr. Becker? I assume your comments are directed about whether we ought to grant the dismissal or not.
No, it's just in response to Mr. Bennett's prior comments regarding some comments about Mr. Lund. I'd like to
You
clarify.
may respond if you like. I don't think that they're particularly helpful in making the determination about whether to dismiss or not.
All right. If you have any questions on that, I'm available.
Thank you.
Thank you.
getting better at those things.
As far as time, it's probably going to be 4 weeks, 3, 4 weeks.
Get around.
Just
Okay, we have a recommendation to dismiss allegation 5. Do I have a motion? Oh, we don't. I'm
we
sorry.
don't have anything on 5.
Ah, we don't have a
We voted
stipulation?
on 4.
Yeah, okay.
And the recommendation
My bad.
on 5 is to proceed to a hearing.
And that, I presume, is what we will do. We don't have a stipulation, and we don't have any,
I'm sorry, and there's no recommendation. It's pleasure of the commission on
right.
item 5. There's not a recommendation either way.
And according to your missive, I believe that the indication was that at least one side has no intent in entering into any stipulation on that allegation.
That's what I was informed yesterday, yes.
All right. So the appropriate thing to do would be apparently to set the matter for hearing. We have a,
Are we going to ask for clarification on the ordinance and the jurisdiction over the clerk? And should we get that before we enter into a evidentiary hearing?
I think that ought to be part of your motion.
So we can, my motion would be that we continue this matter, not set it for hearing, but continue it and request clarification of the ordinance and as far as jurisdiction over the clerk and what kind of penalties, what kind of action can be brought against the clerk, whether he falls within those penalty provisions of 1296 or 8 or whatever it is.
Good. Second. Any discussion?
We're not implying that we've concluded anything, we're just simply trying to figure out what that might look like, what authority and what...
Yeah.
We're delaying setting an evidentiary hearing in the hopes that it will be obviated by whatever legal determination is made concerning jurisdiction of the commission over the clerk.
Mr. Chair, if I may, if you're going to continue this, I would say that the motion should include request of the hearing date that you're going to continue it to, and if you're going to request briefing from the parties, some direction on when those briefs should be submitted.
I was about to get there. Mr. McBride has informed me that he is potentially unavailable on February 22nd. The next date that we have cleared after that is March
March 29th.
29th. So if it's all right with everybody, we'll continue this matter till March 29th and ask that at least 15 days prior to that date that, well, let's see, we probably ought to set up a briefing schedule. 30 days prior to March 29th that we have a legal brief from our counsel concerning the jurisdiction of the commission in this matter, and that at least 30 days prior to the 29th, any opposition that the clerk or his counsel chooses to file will be filed. Any question?
Just on the 30 days again, the same date due, I would think that we would need to review Mr. Smith's.
My intent was 30 days is probably too long. I'd like to have the briefing completed at least 2 or 3 weeks prior to the 29th. And I think 2 weeks in between briefs is appropriate, so
That's
however
fine.
that works out.
I thought you'd said 30 for each, that's why.
I did. My bad. So what does that work out to? 15 days, or, yeah, 15 days prior to the 29th is? The 14th? Okay. So that'll be the date that Mr. Lund's response is due. And if we could have our counsel submit his brief 15 days prior to that, which is? February 28th? Is that agreeable?
Yes, and just for clarification, so you want an opinion on the issue of whether your commission has jurisdiction over to address complaints against the county clerk? Is that correct?
I would like some clarification whether there's any jurisdiction over the county clerk individually, whether there's any jurisdiction and what the scope of that jurisdiction might be over the office of county clerk. Yes, Mr. Bennett?
For the benefit of the explanation, would it make sense to also ask for to what extent, the jurisdiction, but to what extent any administrative remedies are appropriate or could not be appropriate as part of that analysis? I throw that up for a question for you as to whether you want to direct that to be part of that.
Was that your understanding, Mr. Smith? You would address the nature and scope of that jurisdiction?
Yes, I think the question of jurisdiction would encompass the issue of what, if there is some jurisdiction, what, if any, remedies would be possible against the clerk, either individually or in his official capacity.
And the big question is whether the public is limited to the political remedy of election, administrative mandamus in some form to force the particular issue, and if neither of those is a limitation, what the scope of the remedies that the commission can formulate may be. And I suppose that it would be appropriate. Do you want to reply? Do you want to reply, Barry? Motion, opposition, reply. Who's got the burden?
I don't know. I don't think anybody has a problem. Don't worry about it. They'll reply if they've got a real problem.
Okay, undoubtedly. All right, then. That completes item 11 on the agenda, unless I've missed something.
I think they're going to have to get outside counsel.
They might.
I don't know how the office can issue.
I'm already nervous about this. All right, item number 12. Review, receive, and file a report from staff.
Yes, thank you, Chair. Before your commission, this agenda item is a staff recommendation for you to review, receive, and file a report reflecting salient points that was discussed at the November 16, 2012 Commission's study session. I'll be glad to take any questions.
All right. Comments?
Move, receive, and file. Second motion.
We have a motion to receive and file and a second. Any opposition? Then, so ordered. Thank you very much, staff, for the thoughtful
Excellent job.
preparation of the study session report. It must have been a difficult chore with all that was being communicated during that session. Thank you.
I would also like to recognize counsel for his assistance as well.
All right. Item number 13 is receive and file a status report from staff regarding presidential election 2012. Any comments?
Yes, again, Chair, Commissioners, Exhibit 13 indicates you a chart, a matrix, delineating 11 matters would reflect to the 2012 election cycles. From today's agenda, we placed 3 agenda items and moved 1 item to be continuance. With the recent P 2012-10 to be continued to March 29th. As a result of these 11 cases, today you took actions to dismiss 2 cases. P 2012-03, P 2012-04. And the remaining cases are under investigation, and Mr. Craig Steele will provide you that status report.
Any questions or comments?
Would you like to?
Mr. Steele?
Thank you, Mr. Chairman, members of the commission. With regard to Exhibit 13.0, I'll discuss each of these cases, but I'm going to kind of group them for administrative convenience and skip around a little bit. Items 5, 8, and 9, that's two cases involving Firefighters for a Better Government and one involving the Democratic Campaign Council of Ventura County. My investigation in those three cases is concluded, and I had planned to have a stipulation to you on each of those cases at your February meeting. The treasurers in those cases have agreed to the violations. There's no contest. It's now a case of documenting the stipulation. So we're prepared to have that at the February meeting. If that gets continued until March, it'll be the March meeting. But those three items are concluded, and I have stipulations in all three to present to you.
If I might just ask a question of staff, is there a point in having a meeting on the 22nd where only two of us would attend? We could take care of Mr. Steele's matter.
Stipulations, yeah.
Yeah, just take the steps.
Well, the standard operating procedure indicates that to have a meeting quorum, 2 out of 3 commissioners will
Right.
allow for the commission's meeting. To timely address the work use in compliance with the ordinance, the 30, 60 days, and the 90 days, it is staff recommendation that the commission should convene in February to address and receive the stipulations and make a final recommendations on those stipulations so that we can promptly notify the complainants and the respondent.
Okay, that's the
Good idea.
Doesn't seem like there's any reason not to. Would you prefer not to have one?
I don't mind, I just didn't know that I need fewer things than to mess with when we have to. Okay.
Yeah, that was my only thinking. That's all we got on board then. All right, then we'll go ahead and schedule that matter or those matters for the 22nd.
In February. Thank you. The same would be true, or I would make the same request with regard to item 1. I will be presenting a recommendation as to a disposition of that case at your February meeting. Items 6, 11, and 7, I'm sorry, 6, 7, and 11 are all related in that they involve the same respondent and the same treasurer. That investigation, because I just received 11 when I returned after the new year, that investigation is not concluded, and I will be meeting with the treasurer of that committee on those 3 items. At this point, I have no stipulation to report to you, so I would request that they be scheduled for hearing at the March meeting, although I will continue to work toward resolving those cases, but I would request that they be set for hearing in March.
Once again, to reiterate, that was numbers...
6, 7, and 11.
All right.
I apologize. I think to be technically compliant, I should say it was 6 and 7. 11 has just been received, and I'm within the 30-day period, so I should not make that representation as to item 11, although they are related. So specifically 6 and 7, I would request that they be set for hearing in March.
Is that agreeable with staff? All right.
And 11, I will give you your initial report, I guess, at the February meeting now.
Great.
Thank you.
Thank you. All right. Anything further on 14? We want a motion to receive and file? Second? Any opposition? All right. Number 14.
Thank you, Chair. This agenda item is a recommendation for you to review, discuss, revise if any, and approve the Commission's report to the Board of Supervisors pursuant to the Ordinance Section 1297M. The Commission must provide a report of the activities to the Board of Supervisors at least once every 2 years, beginning January 2013. As such, staff has prepared the activity summary for you to review from the 2010 election cycle, as well as a status summary of the 2012 election cycle. Staff also prepared for your commission a fiscal report reflecting the administrative cost in the last 3 full fiscal years and the total incurred cost for the first 2 quarters of the current fiscal year. It is recommended that your commission approve the activity summary report, authorize your chair to sign the cover letter on behalf of your commission, and direct your staff to file this letter and the summary report to the Board of Supervisors. And I also like to add, under a separate cover, staff will be filing a board letter to request the board's approval and authorizations of your amended policy.
Now, we adopted those this year, didn't we?
Yes, the commission reviewed the ordinance, discuss the amendment changes to reflect the ordinance in your operating procedure at your November 2nd, 2012 meeting.
If I recall correctly, the changes to the policies and procedures were really to conform to the number of the new revised ordinance.
That is correct.
Okay. Do I have a motion to receive and file and authorize the chair to sign the report? Any opposition? Hearing none, that's approved. There being no further business before the commission? Oh, yeah. I have one, but he's had his opportunity. Is there any further public comment? No further business before the commission, we stand adjourned. Actually, and continued. Yeah. Johnny, take this job back.